Welcome to the She Said Privacy, He Said Security podcast. Like any good marriage, we will debate, evaluate, and sometimes quarrel about how privacy and security impact business in the 21st century.
Hi, Jody Daniels here. I'm the founder and CEO of Clover Advisors, a certified women's privacy consultancy. I'm a privacy consultant and certified informational privacy professional providing practical privacy advice to overwhelmed companies.
Hello, I am Justin Daniels. I am a shareholder and corporate M&A and tech transaction lawyer at the law firm Baker Donaldson, advising companies in the deployment and scaling of technology. Since data is critical to every transaction, I help clients make informed business decisions while managing data privacy and cybersecurity risk, and when needed, I lead the Legal Cyber Data Breach Response Brigade.
And this episode is brought to you by Clover Advisors. We help companies to comply with data privacy laws and establish customer trust so that they can grow and nurture integrity. We work with companies in a variety of fields, including technology, e-commerce, professional services, and digital media. In short, we use data privacy to transform the way companies do business. In short, we use data privacy. I really want to say, in short, we use data privacy to transform the way companies do business twice because I'm confused. So, anywho, to learn more about us and to check out our best-selling book, Data Reimagined, Building Trust One Bite at a Time, visit redcloveradvisors.com. I'm clearly very confused because I'm...
Did you take enough coffee?
I did, actually, but maybe I melted because I had coffee outside in the Atlanta humidity this morning.
Ooh.
I wasn't quite planning on the outside, but that's okay. It was really good. And we're recording during World Cup season. And Justin, right before we hit record, you shared something cool.
Apparently, the World Cup teams are staying at the hotel literally connected to our office. So I guess Argentina and who are they playing today? England? They were heading down to the...
You need to get this information earlier next time because we could have moved the recording and maybe seen cool World Cup people.
Didn't know that you were so interested. Sports is not normally your forte.
But the World Cup is the World Cup.
Yes, like you like the Olympics.
And I have no interest in going with a couple 100,000 people to the fan fest. So instead, at a distance in a hotel would be a lot easier. Okay, but I suppose we should talk about privacy because today we have a longtime privacy friend, Ben Isaacson, who for more than 25 years has been a leading privacy professional and trusted counsel. And during the Internet I Love 1.0 era, he was instrumental in launching the first self-regulatory guidelines for email marketing, addressable TV, and mobile marketing. Ben has an incredibly long bio. If you are listening, please go to the show notes so you really hear all about how amazing he is. And fun fact, he was one of the first privacy professionals to get certified as a CIPP US with the IAPP in 2005. So Ben, we're so excited that you are here with us today.
Thank you. Great to be here.
So Ben, why don't you tell us a little bit about your career journey?
Yes, in fact, I need to change that bio because as of this week, it's 30 years. I've been in the same industry doing similar things. My career journey started as an intern with a kind of fledgling startup trade association in Washington, D.C. that was focused on interactive television, and then quickly morphed into becoming the Association for Interactive Media and covering sort of the internet as well as interactive television. And I was the first registered lobbyist for the internet industry in 1997, and have been working at originally in public policy, and then I took over the trade association. It got acquired by the Direct Marketing Association, so I was really got my deep learning in data brokers, which we're going to talk about because that was the DMA, for 100 years before they got acquired by the Association of National Advertisers. And then I joined Experian for 10 years and got really deep in the weeds on what is a data broker and all of the disparate data activities that around the world, because Experian really is a global conglomerate, not just early U.S. business. And then for the last 10 years, I've been in private practice doing, my own law, as well as AI and other kind of new innovative technologies that kind of intersect with data licensing and ad tech and marketing tech and kind of all the things that we're going to talk about today.
And so, huge hint, talking about data brokers. And Ben, you always like to help kind of set the stage for what is a data broker. And a lot of companies have that question, which is, are they a data broker? What is a data broker? And then if you want, we could throw the monkey wrench of New Jersey's new law that we may or may not need to be paying attention to, depends on the day, where they have data collector as a new definition. So help us understand these definitions and maybe how how companies should be thinking about it.
Yeah, I mean, with the exception of the New Jersey thing, which we'll talk about, I think the common broad definition of data broker is entities that sell data that they didn't collect themselves, that they don't have a direct relationship. They're hiding in the background. You don't know who they are. They compile data from all different sources and then they sell it to whoever will buy it from them. There are really two categories of data brokers that I like to make sure everybody's familiar with, because there's the category I think that most people think about as a consumer in their head, which is the profiling, individual search kind of, the Spokios of the world, that really provide, tell me about that person. And that might be for background check. That might just be for, rental verification, anything that, companies might use to say, or individuals even might use to say, this person has got this background or some information about them that I need to know. And those are sort of the directory type services, right? But I don't work with those companies, by the way. The companies that I work with are really in the second category, which are really large scale, more advertising, marketing, trying to reach broad basis of individuals or devices that again they don't have a direct relationship with, but they just want to build information about or those individuals or predictions. Now the laws that are on the books now take a very different approach, combining these two into one common definition. California is kind of being the benchmark for, I think, all of the definitions, because they've come out with regulations and made it very clear what their definition is, that a company that does not have a direct relationship, and there's really a subjective standard there now, which is going to be interesting to see how it plays out in the next few months, where did the individual know that they had a direct relationship with that entity, even if the entity did collect the information from them. So there's kind of a two-step process to define what is a data broker. Did you collect it? If you didn't, you're automatically, and you're selling it, you're automatically a data broker. But if you did collect it, and you either were still in the background somehow, that the individual didn't know you were collecting it, or that you're enhancing that information with third-party data and then selling that information, California is going to consider you to be a data broker, with significant penalties, as we might talk about here, if you don't register and comply with their Delete Act. The other states are very different, and there's a lot of different nuances between the 5 other states that now are on the books with data broker related definitions and registrations. Some, like Oregon, really exempt business to business sort of professional, B2B targeting or B2B data profiling. Others are more focused on, is your business, like Texas, is your business really focused on data brokering, or is it sort of an adjunct to, everything else that you do? So there's sort of a threshold to the primary purpose of what you're doing with that data licensing and sale. And again, and then obviously New Jersey is its whole other beast now that just came to fruition around this combination of, are you a data broker and a data collector that needs to register because you're just selling data to data brokers. So that's, again, I'll pause there because there's a lot to unpack. But it is getting more complex across the states, seemingly every few weeks now.
That is true.
So when you compare the laws in these different states, California, Connecticut, Vermont, Texas, New Jersey, how many states are there with data?
Well, there's
There
a
are six states now.
Huh,
New Jersey's the newest one to join the party.
I see.
Yeah.
What kind of themes are emerging? Because I guess what I would ask both of you is, and I've asked this about other laws, is How much are these going to deter people? Because these data brokers, it's so lucrative. Where do they get the resources to prosecute people and actually make them pay big enough fines that they're going to care?
Well, I mean, I think California is the trendsetter. I mean, historically on privacy, and I think with data brokers, it's been an interesting evolution watching it go from, simple transparency of, hey, we just want to bring these hidden companies into the light. And I think that's the number one theme all of these states are really following is that for, generations now, it seems like data brokers have been in the background selling data that consumers had no idea how you opt out, who they are, what they're doing, and that the number one objective of all of the states is to say, hey, we want consumers to know who these companies are. So California started that ball rolling. Actually, Vermont started the ball rolling on that, and then California quickly followed and enhanced it. And then, to say, okay, this is the name of the company, this is an email address, this is a website, this is how, you potentially can learn more and opt out if you want to go opt out. And again, not necessarily requiring that opt out, but, but at least making the privacy policy available. And California obviously evolved with the Delete Act significantly to say we want to empower our consumers to opt out or delete really their information. It can function in a two-step process from deletion to opt out, but we don't have to get into the mechanics. The important thing is that is the trend now, and Connecticut just followed suit a few months ago, saying we are going to create the same sort of deletion mechanism that California is implementing in 2 weeks to allow our consumers to get out of being sold, essentially. And again, the pragmatic way of going about that, which New Jersey is not exactly following, is to say, we're going to allow consumers to register with California. We're going to require them to verify their residency, and then we'll create this really technical mechanism to synchronize with all of these data brokers to provide that accountability and authentication needed to say, okay, we will actually delete your information and suppress it moving forward. So that's sort of this trend line. New Jersey again took a very different path for very interesting reasons, as I've come to learn. But again, I think the California and Connecticut combination is now a model for other states to follow, to at least empower their consumers to not be sold, I guess is the simplest way to say it.
So Ben, tell us a little bit more about New Jersey and its unique diversion from these other states. What do people need to know about Jersey?
Yeah, I've learned a lot in the last week or so. I've never really followed New Jersey politics. I think what's fascinating about what's been going on is New Jersey has a fiscal requirement to balance their budget every year, which I think is a great thing for states to consider. But when they get into the sausage making and at the end of that deadline they're not balanced, they need to figure out a way to increase revenue. And so my understanding, and again, Bloomberg Law reported on this as well, so it's not just me saying it, is that this law that was introduced in both houses, the Senate and the Assembly, passed out of committee, passed out of both floor votes, and was signed by the governor within 4 days, which is unspeakably crazy in any kind of lawmaking, unless there's, again, an emergency, but there was obviously no emergency here. The emergency was the fiscal gap. And so they created this mechanism to, potentially raise $50 million. I think that's the number they're trying to gap fill by creating a tiered structure for data brokers to register with the state based on the processing of New Jersey data. And so theoretically, this, again, conceptually, whiteboarding that kind of idea makes some sense on a whiteboard, right? How do we get $50 million from an industry that no one really loves and doesn't understand, and what the implications are? It doesn't really matter. We're just going to put it on the books, and then the governor can sign it, and we can say, yep, we balanced our budget. So that's my understanding of the genesis for the law. They didn't really think about, little things like the U.S. Constitution and how it might, not allow for these kinds of, fee-specific registries that are based on, sort of volumes of data that no one can possibly correlate to New Jersey residents, or, free speech grounds or any of the kind of other challenges that might come up. The main thing here is that this was done so quickly that they really didn't consider all of the implications of the definitions that they put into place, because it's not just data broker as we've defined it. It's data collector, which they are defining really as any companies that sell data to data brokers, which when you look at like the list of, California registered data brokers, which is, public information, you can see a whole lot of companies on there that are the mechanics of the ad tech industry, for example, that just supply sort of the exchange of real-time information for bidding on ads. So any kind of company that's an ad-supported company, for example, publishers, of websites that are ad-supported, likely work with one of these data brokers. So all of a sudden, like every ad-supported publisher is now a data collector, and will have to comply with this New Jersey law. So, $50 million might be, again, if it's possibly enforceable, is not even close. It's probably $5 trillion. It's like the whole economy of the ad-supported industry, plus all of the sort of interesting new companies in the like retail media networks that are, Best Buy, for example, that has now ads that are built into its like listings of, products on the shelf. Those kind of companies that are going to work with these real-time, ad exchanges and whatnot. So you have, all sorts of industries now that I think, again, New Jersey just couldn't have really thought through in, 2 days, are impacted by this law. And just, again, the fact of trying to comply with it without knowledge of who is a New Jersey resident is technically impossible. So I think, we'll see some change to this law before it goes into effect. At least on the data broker and collector side. There's another part of this law that was really interesting that got sort of pushed through at the same time, which was the ban on sensitive personal information sale. And so, they're not the first state to do that. Maryland was the first state. But what's really interesting, again, like they just passed a comprehensive data law, privacy law a year or so ago. That law just came on the books. Companies are just starting to enforce it. It included an opt-out for sensitive personal information. Now it's just banned as of today. Like it was banned as of July 2nd. It's not, they just went into effect. So again, not a lot of thought in terms of how that implication of immediate enforcement is in effect. But again, we'll see if that stands up, after, the next legislative session or however it might get amended before too long, I guess.
You hinted that this is an industry not everyone loves, and maybe this is an area of opportunity. So I'm curious from your point of view, in general, we have 6 of these data broker laws. What do you think is driving the increased focus on data brokers? And if you had a crystal ball, what's your prediction? I don't know, pick your time horizon of the next year, what we might see for data brokers.
I think there's a few things in play here. I mean, and one, I have to kind of start with having been in this industry for so long that again, it's kind of sad to see that the Direct Marketing Association really went away, right? And the Association of National Advertisers that acquired, the former entity of the DMA really hasn't focused on data as a coalition building effort around public policy. And so there's really no industry that represents these companies anymore. Or industry organization, I want to say, or coalitions that really represent these companies in a way that can help educate legislators that data is important to the commerce of the United States. And so and again, differentiating some of the harms that might come from data broker activities. Again, some of those background check type services that may not have, full FCRA compliance or other laws that might intersect with them should be, again, focused on where there could be fraud or other identity theft things that are happening in those industries versus kind of the ad tech, marketing tech, industries where it's harder to pinpoint any sort of harm that other than the sensitive data piece maybe that really needs the same type of regulation. So I think there's really no friction. I think simply put, in the public policy space. B, it is relatively bipartisan. Like this isn't a Democrat Republican thing. Like there are very few issues right now where the two parties could come together and say, yeah, this makes some sense from a privacy or consumer protection perspective, and we're really not looking at it from a particular harm perspective, but hey, let's raise a few bucks, as New Jersey's trying to do here. And again, California, I think, came at it from a different, really more fundamental privacy perspective. Tom Kemp, who's now the executive director of the California Privacy Protection Agency, was actually a co-author, behind the scenes, of the Delete Act. He has been a longtime consumer privacy advocate and really wants to align U.S. law with like European law and the fundamental right to privacy. So there's a perspective that I think that Tom and other California advocates have taken over the years to really kind of philosophically align privacy with the world, whereas others are like New Jersey are maybe coming at it from a very different angle. But again, there's not much friction. There's no not a lot of lobbying dollars coming at it. Unfortunately, that's really what's needed here to create more balance in some of these laws from being enacted.
Speaking of California, how does the California Delete Act fit into the broader trend of state data broker regulation? And do you expect other states to follow a similar model?
Yeah, I think as I think I hinted at, like it feels like the Delete Act is now the blueprint for the country. And there's obviously been talk on the federal level as well since the California Delete Act came into effect, is, hey, back when, kind of the Telephone Consumer Protection Act was being enforced, the FTC came up with, the Do Not Call registry, and, it's been enacted for 20 plus years now, and it works very well. Why can't we do the same thing for data brokers and the whole country and preempt these state laws? Now that I think that's going to come to a head. Obviously this legislator, this session of Congress and this body of Congress is not that motivated to get anything done, it seems like. But again, like we're seeing this blueprint with California and Connecticut now. There are many other states, New York, I've heard Nebraska, other states are now closely looking at a similar blueprint. So I suspect we'll see, a dozen of these Delete Acts get passed in the next, year or two before Congress really gets their act together to really look at a federal solution. But ultimately, I think there kind of has to be some sort of federal solution here to preempt this, because operationally, just, it's going to get unwieldy for companies to really be in that space, especially if that data collector definition gets added on. So if New Jersey really is able to maintain that data collector definition, and that other states see that that's enforceable. And again, the revenue side of that could be significant, especially with enforcement penalties. That blueprint could extend very quickly to other states that are just looking for, again, easy revenue from companies that aren't able to really defend against these kinds of overburdensome regulations.
With multiple different data broker laws right now and slightly different definitions, what do you recommend companies do to start and figure out, are they a data broker?
I don't want to sound crass, but get a legal opinion, I think is the simple answer here, because it really varies significantly depending on the nature of your business. And really the most important thing is the nature of your commercial terms in terms of how you're licensing data from and to different companies. And even California has very rigid guardrails on who can be deemed a service provider. And again, if you're in the ad tech industry, like you can't be a service provider pretty much under most California, scenarios. But again, you might be able to split California from other states and like in terms of your contracts. So it really requires close scrutiny of commercial agreements for all types of data use. And then the monetization of that data, if there is a sale taking place or a license taking place, what those licenses are, and it's not easy to geofence California or New Jersey or these other states just by like IP address or things like that because those are possible attempts to comply, but they're not solutions legally. So you have to kind of look at that risk and say, okay, well, we're trying to comply just by geofencing in California or one of these other states, but it doesn't necessarily mean you're actually in compliance. So it requires a lot of legal scrutiny. Unfortunately, it's getting more complex, and that's the simplest answer.
I appreciate you sharing. It is complicated.
So what should companies who just buy data from data brokers be thinking or doing? Is there an impact to them?
Yeah, this is an increasingly novel issue around like what I'll call downstream liability for licensees of licensor data that now needs an enhanced like layer of compliance. And so this Delete Act in particular is really new because again, it's only coming into effect really August 1st in 15 days, where if you're licensing data from a California data broker, they must apply that deletion data in advance of you really using that data. And especially, again, if you're reselling as well, which I'll get into a sec, but like the most important thing is that that like typical thing that you have in your contract that says you must comply with the law. Very simple. Everybody has it. But in this world now where there's accountability and there will be audits on that accountability as well, you don't want to have that data in your database if, again, that consumer has expressly said, I don't want to be sold. And again, the liabilities doesn't necessarily mean that California is going to come after the licensee because the licensor didn't apply it, but there might be uses by that licensee that get implicated that could create liability under CCPA and other laws as well that may require investigation by the CPPA or other attorney general or others. So the answer is, really button up your commercial terms with all of your data licensors and very, very closely scrutinize the licensing relationships you might have with any sort of ad tech companies that you might be working with, because this sort of push pull on just data licensing in general is going to be highly scrutinized, and the penalties. I just have to state very, very clearly, the penalties for non-enforcement in California are bankruptcy level, statutory penalties that are bankruptcy level penalties, because it's $200 per day per violation. So if you have, again, there are 300,000 individuals now on this drop, deletion list. So if you combine, $300 with $200, that's, a significant amount of money just for one violation. And you compound that over days and weeks or months, and you can do the math. You're not really in a position to pay those fines, unless you're maybe Google or some mega company. So any of the data brokers or data licensing, companies in the ad tech space really are in a bad position where if they don't like really button things up, they could face statutory penalties that put them out of business.
And I want to add to anyone listening. So this, I think, is an opportunity for privacy and legal teams. So anyone listening who's familiar with the California Delete Act, to talk to your sales teams and your marketing teams and whomever is purchasing that data. They might not be aware. And what I think is going to happen is over time, on day one, it's not going to be a massive drop all at once. You might not experience all 300,000, but that pool of data is going to continue to increase. And in terms of the number of people who want to opt out, which means you will start to feel the impact. Those teams will see a decrease, and they might appreciate the partnership to be able to say, here's what's happening in the industry, and here's how this might affect the business, to give the business some time of how they might need to adjust if they can't always rely on all the data that they're licensing and purchasing.
Yeah.
And with that being said, we always like to ask each guest, knowing what you know around privacy and security, what is your best personal tip?
I mean, if you're, I have to say it, if you're a California resident, go register with the drop. I think it's
Go increase my numbers.
I mean, look, again, from a personal privacy perspective, this is the most powerful mechanism that's been introduced in this country. With, I mean, again, do not call was helpful, but again, there's sort of loopholes around that, around like consent, for example. And so you can still get telemarketing calls. And again, the enforcement, even in a private right of action, hasn't been wonderful. So you still get calls, right? You still get texts. You still, that sort of thing still happens. With this deletion mechanism for California, there's no consent override. Like once you're on that list, you're on it forever. You're not, I mean, at least unless they verify your residency again. But, as long as you're a California resident, there's nothing these data brokers can do to put you back on that list. So it is a very powerful way to protect your privacy. And you'd be surprised, again, knowing what I know, like just how many companies this really implicates. And, again, from a personal perspective, there's one thing that I think the misnomer, I think, is that you shouldn't unsubscribe from commercial email. But in all of my years of working with emailers and understanding email service providers and how the mechanics of it, it really works well. So, don't let it just go to the spam folder. Just unsubscribe. Don't let it clog up your promotions box. Just unsubscribe. That's really the simple approach that I've always advocated to people.
Those are two great tips. I wished I lived in California, but I have no rights here in Georgia.
So, Ben, what do you like to do for fun when you're not so engrossed in all of this privacy advocacy that you do?
It's hard to say one thing, but I guess, I guess I'll just say like I'm a big Grateful Dead head and jam band fan. Always have been since I was like a teenager. So I'm like seeing, Grateful Dead cover bands and every sort of version of, band that's come with them. I just saw Fish for 2 nights last week. So it's, that's my favorite enjoyment.
And then if people would like to connect with you or learn more or follow along on all things data brokers and other fun privacy topics, where can they find you?
Yeah, I'm pretty active on LinkedIn. I try and post any thoughts and feelings and ideas and anything that comes to mind that I think are relevant here as much as possible. So that's definitely the best place. Our website is inhouseprivacy.com. We do post a lot of blogs and things on there as well.
Well, we are so grateful that you came today to share with us. So thank you again.
Yeah, thank you for having me. It's been great.
Thanks for listening to the She Said Privacy, He Said Security podcast. If you haven't already, be sure to click subscribe to get future episodes and check us out on LinkedIn. See you next time.